Senior Lecturer in International Tax Law, Academic Director at Institute of Tax Law, Director LLM in International Tax Law, Dissertations Director at Center for Commercial Law Studies, Queen Mary University of London, United Kingdom. On behalf of Institute of Law, Nirma University, I welcome you, Professor Schneider. Please. Professor, now the floor belongs to you. Professor, I think your mic is on. Professor Schneider, am I audible to you?
Professor, your mic is on mute.
I apologize. Okay, there we go. Thank you very much for that very kind introduction, Dr. Powell. It's my pleasure to join Nirma University's Institute of Law for its International Teaching Month this year, and to give you a brief lecture, which I hope you will find interesting, on the UK and Indian GAARs, because they're both very interesting, fairly recent, and as we will see, quite different. Really quite different. So on that note, if I can share, hopefully I can share my screen. Okay, rather not the whole screen, but the slides. And I want to take you today, all of you, through a lecture about the UK and Indian GAAR regimes and some comparative discussion of the two. But before we do that, we really need to think and talk about tax avoidance, because that's really what both of them, in their different ways, are trying to address. So I'd like to spend some time before we actually start to look at the UK and Indian GAARs specifically to look at tax avoidance and the different approaches to tax avoidance, specifically specific anti-avoidance rules, judicial principles, and then GAARs generally, in order that when we get to hopefully when we get to the UK and Indian GAARs, the context will be clear, right? And the differences will jump out at us, if you will. So the fundamental problem, or at least certainly from the revenue authority's point of view, and to be fair, generally speaking from a tax policy point of view, is what kind of avoidance, if you will, of taxation should be permissible. Okay, and I use avoidance here, with a bit of trepidation, because different connotations have been attached by different people in different jurisdictions at different points in time to the various terms that are used as I'm sure you all know: tax planning, tax mitigation, aggressive tax planning, tax avoidance, tax evasion, and we could spend an hour or two just talking about the thicket that is the terminology, and trying to make distinctions, right? Fundamentally, we're trying to make a distinction between what we consider improper, proper or acceptable or expected or intended by Parliament, or the legislature, tax planning, and that tax planning which we consider improper, unacceptable for whatever reason. And of course, taxpayers want to maximize their ability to reduce the tax burden. And I'm assuming here, for the purposes of our discussion, that we're not talking about in clear contravention of law or regulations, right? That's evasion, right? Or at least certainly the way I would use the terminology, that's tax evasion. That's not what we're talking about, right? If it's tax evasion, it's not okay. You as future tax or other practitioners, cannot condone it, cannot recommend it to the taxpayer, to your client or to yourself. But that's not what we're talking about. We're talking about all the other stuff. So taxpayers want to increase their room for maneuver, if you will, and jurisdictions want to limit the ability of taxpayers to do so. The problem is that this is difficult, right? Again, assuming that we're not talking about clearly illegal behavior. It's difficult for a bunch of reasons. No system can address or even envisage all possible scenarios, because if you did, you would have a tax code or an income tax act in India, or whatever the primary statutory instrument is, or regulatory instrument, that is even longer and even more complex than it is already. And I know enough about the Indian system to know that it's already quite complex. So you simply can't do it, and that would assume that it's a static situation, which it's not. Business structures change, transactions change, commercial realities change, technology changes, right? Supply chains have changed over the last 20 or so years, which have given us all sorts of, for example, just as a semi-random example, which have given us all sorts of issues around transfer pricing that nobody really worried about very much 30 years ago, because we didn't have those flows within MNCs or multinational groups and so on. Technology changes things. Some clever investment banker in London or New York or Mumbai comes up with a structure or an instrument that wasn't contemplated in the statute, and now you have to figure out what to do with it, and so on and so forth. So it's not a static system at all. It's highly dynamic. And the other, and the more you try to address this, the more complex it gets, right? The more you try to address specific scenarios, even as they arise, the more complex it gets. And there is also an inherent problem in most tax systems. I won't say all, because I can't claim to have looked at all, but it certainly seems to be true in most tax systems, that you're trying, which is to say the system, the legislature, the policy people are trying to accomplish more than one thing, and the gaps or the contradictions between those purposes, or between the instruments available for doing so. The classic simple example is, you run a business as a sole proprietorship, you run it as a partnership, you run it as a corporation, right? That's the sort of the classic example. So the differences that are there, perhaps for very good policy reasons or even social policy reasons, then create planning opportunities. So it becomes, let's say, very, very difficult to do this, to limit this in any principled way. And as I've suggested, perhaps already in what I've just said, there is a conflict, I would suggest an inherent conflict between simplicity and predictability on the one hand, and simplicity and comprehensiveness, and also between simplicity and comprehensiveness. The more you want the system to be predictable, which is to say to allow the taxpayer, and for that matter the revenue authority, to know what the result will be in a given scenario, the more complex it's going to become. And complexity beyond a certain point at least creates all sorts of problems. Just look at the level of litigation and taxation in India, right? Which all of you are more familiar with even than I. And similarly, as I've definitely already said, comprehensiveness means more stuff, more complexity, and simplicity goes out the window. So that's fundamentally the problem. There are three primary ways to deal with this. One is to have specific anti-avoidance rules in your tax legislation and or tax regulatory structure. They address a specific scenario, hence the terminology. In Britain, these are sometimes referred to as TARs, targeted anti-avoidance rules. I know that I understand that in India you typically refer to them as SARs. I would also, being originally North American, as you may be able to tell from my accent, I would also think of them as SARs. But fundamentally, it's a specific or targeted rule that will limit or negate some tax benefit or prevent the access to a tax benefit that would otherwise arise if you don't satisfy the rule. And tax systems are full of, some people would say littered with, SARs. Controlled foreign company or controlled foreign corporation regimes, thin capitalization, various regimes for dealing with below market interest rates, limits on interest deductibility, taxation of passive investment, income splitting rules between spouses, moving losses around between companies in a corporate group, transfer pricing. They're all examples of SARs. I put a question mark in brackets next to transfer pricing because it's kind of its own universe, and it is itself so complicated that you could think of it as a kind of a GAAR. I've seen it referred to as a SAR. I can see the logic behind it. I can also see the logic for arguing it's not really a SAR because it's not that targeted, right? We all know that the principle of transfer pricing, it looks good and simple on paper, but the reality of trying to figure out what a arm's length transaction or arm's length price means, makes it, to my mind at least, look very general, much more like a GAAR. Many jurisdictions have one or more, probably most jurisdictions have one or more of these kinds of SARs. They are specific. They tend to be effective, right, because they're looking at a particular scenario or set of scenarios. They are clear. Well, clear if you're a lawyer or a law student or an accountant, anyhow, maybe not clear to the average educated person, but they are susceptible to being clear and certain, right, with sufficient close reading. They are presumably, if we're in a rule of law jurisdiction, as India and Great Britain certainly are, consistently applied, and they're known in advance. So they satisfy a lot of the major requirements that we would associate with rule of law in taxation. Okay, so they are, in that sense, very strong. They're very good ways to deal with tax avoidance. But they also have some serious disadvantages. They're reactive in nature, at least initially, which is to say that typically, some SARs come in very early in the sense that someone drafts some legislation or you have a particular aspect of the tax system, and already in the legislator, you always ask yourself the question as a policymaker or as a writer of legislation or regulation, if the rule is X, what is the taxpayer going to try to do, or what are his, her, or its advisors going to try to do get out of taxation? So sometimes it's really early on, but as the rules become more complex and as the system develops, they tend to be reactive, which is to say there's a loophole. Someone, again, taxpayer or its advisors, exploits the loophole, or if you wish, if that's too sort of biased a term, you can say takes advantage of the loophole, right? Utilizes the loophole. The legislature or the revenue authority reacts, so it's reactive, and then the SAR is put in place. It therefore is often time lagged, and you get back to the points we've made before, which is that the specific nature of the provision tends, and the technical nature of the attempt to plug the loophole tends to create more loopholes. So you get this so-called arms race between the taxpayer and the revenue authority, which leads to more tax planning, more complexity, and so on and so forth. Another way to go, which again exists both in India and in the United Kingdom, both being, of course, common law jurisdictions with established and independent judiciaries, is to go for or to have a system where there are what might be called, I've just made this acronym up in my head, I've never seen it, GAARs, judicial, if you will, anti-avoidance principles. Typically in the common law, they will have been developed first in the judiciary, but they may be subsequently be supported by specific authorization, or even incorporated into the statute or the regulations explicitly. There are many examples of this in different jurisdictions based on economic substance or commercial purpose, the notion of substance over form, concept of legal fraud. I don't want to spend a lot of time on it because I want to go through everything, of course, and all the slides, particularly about the GAARs specifically, and leave hopefully some time for questions. But needless to say, first of all, that if you look at the case law, I must confess, not particularly familiar with the case law in India, but certainly the case law in the UK and in Canada and the States, which I'm more familiar with, it's inconsistent, or arguably inconsistent, right? You look at a body of case law and you think, well, if I was following principle X in case Y, I wouldn't have ruled that way, and so on and so forth. And different terminology is used to different effect in different jurisdictions, sometimes over time, and so on. So it's not a clean system. It does provide, in principle, the flexibility that's not generally available in SARS. But then it has its own disadvantages. One, first of all, that it is very reactive. Here it's by definition reactive because it only arises, at least in the first instance, in a particular litigation, right? So it's reacting to something that's already happened. Going forward, it may have a deterrent effect, but certainly not initially. In principle, it's limited to the parties to the litigation, and then, it may not be applied or understood consistently, and it requires an effective judicial system, which, again, at least in India and the United Kingdom, is certainly not an issue. And then you also get into all sorts of interesting questions about the judicial interpretation of the law, literal interpretation versus purposive interpretation of tax law. How literally should tax legislation be interpreted, and if you're looking at the purpose, what purpose, how is it to be determined, how broadly is it to be determined, and so on. And a lot of the issues around judicial interpretation of tax law in particular is what has led, at least in some jurisdictions, let's say at least in the major common law jurisdictions, I think it's fair to say, to the rise of the GAAR, right? The implementation, the move towards GAARs. So, what is a GAAR? So, it's an attempt to deal with tax planning proactively by providing some sort of general anti-avoidance rule that can be invoked by the revenue authority against the taxpayer. And typically it allows the revenue authority to disregard or dismantle arrangements, agreements, transactions, and substitute hypothetical arrangements or agreements, or actually, I should have put it even more broadly, also recharacterize income, reassign residence, situs, etc., and typically in whole or in part, right? So it's potentially an extremely broad power, which gives a lot of discretion potentially to the revenue authority, which in principle we should be nervous about, because you do not want the judge and the jury to also be, the executioner to also be the judge and the jury, so to speak. And also because, as a matter of constitutional and administrative principles, we generally think of the revenue authority, the executive, as being the executor of the law, but not the determiner, right? So the law is set by the legislature, and determined by the judiciary, at least the principles, if not, of course, necessarily every case. And the executive is only supposed to be executing, right? That's what executive means. And if you give them too much discretion and too much power, you start to tilt that balance. So it is something that we should be nervous about, in principle. GAARs raise a whole bunch of related issues. So one is something that I've elided so far, but which I'm now going to make explicit, which is, what's the second A in GAAR? Is it abuse or avoidance? Is it crafted to deal with avoidance in general, whatever that means in the system, or whatever that's defined in the system, or abuse, which again, as defined, or as understood at least, maybe defined is too, assuming too much, but as understood in the system, because the latter presumably is much narrower than the former. Okay, so that's one very fundamental question, right? That's hidden in that acronym. Right? The first thing you ask yourself when you hear, or when if they've used that acronym, jurisdiction X has a GAAR, the first question you should ask probably is, what do they call it? On the assumption that the label, that the title fits the reality, right? The first question is, what do they call it? Another question is, to which taxes does it apply? Right? And the related question sometimes is, where is it embedded? Right? So where can you find the GAAR? Because presumably the GAAR relates to whichever statute in which it is located, so to speak. Right? We'll come back to that as well. Who determines what is subject to the adjustment? Okay, typically it's the revenue authority, but what happens afterwards, right? So the initial assessment is in the revenue authority. That's the whole point. But who in the revenue authority? What's the procedure in the revenue authority? And where does it go from there? And how is it reviewed? And perhaps finally, the major issues is, who has the burden of proof? Right? Is it with the revenue authority? Is it with the taxpayer? Where does it start? Where does it end? Okay. Just see if there are any questions in the chat. Right, not yet. Okay. Okay. So let's proceed for the moment. So the advantages and disadvantages of GAAR, of GAARs, they provide flexibility not available in SARs. They have the potential, at least in theory, or at least it's been claimed that they have the potential to end the arms race between the revenue authority and the taxpayer. They are somewhat reactive in nature because they're still depending on the taxpayer having done something. But it's not reactive in the same way. So maybe I should have put that in. Actually, I probably should have put that in the advantages category. Much less reactive, right? They are, however, applied post facto. They have the risk of being applied inconsistently, depending on how much activity is going on or how widely the net is cast, and so on and so forth. Arguably, they require an effective review system or judicial system of some sort. And from an economic, etc. point of view, they may chill legitimate business transactions and structures. Okay, so let me pause for a second. Are there any sort of thoughts or questions from anyone so far? I don't see anything new in the chat, but
Professor, you can continue. We'll be taking question in last 10 minutes.
No problem. No problem. I'm always happy to entertain questions at any stage, and that was a good place for me at least to stop and catch my breath for a moment. Okay. So let's talk about the Indian the UK and Indian GAARs. I'm more familiar with the UK one, but let's start with that in any case. So first of all, the top of the slide tells you already a very important thing. The UK GAAR is an anti-abuse rule. It was first raised in 1997 by Gordon Brown, as it happens, the first Labour government in 1997. The reaction to it was a bit mixed, and I don't just mean that taxpayers didn't like it, because invariably taxpayers don't like the idea of a GAAR, or I would say normally you would expect taxpayers not to like the idea of a GAAR because it gives the revenue authority more power. But that aside, my point is more that the reaction was mixed from academics and policymakers. Right? Because the original proposal, or it wasn't a fully fledged proposal initially, but as the first consultation came out, it looked like HMRC was going to propose a fairly broad anti-avoidance rule. And a lot of the reaction to that came out fairly negative. And 2 years later, the government confirmed that it would not proceed with the GAAR. and it seemed to be dead, at least as a matter of legislation. But of course, the academic and policy discussion continued. In 2010, with a new government, this came back on the agenda, so on the legislative agenda, but as part of the announcement of a consultation on the GAAR, the HMRC, or Treasury, Her Majesty's Treasury, established a study group led by Graham Aronson, typically referred to as the Aronson Commission, and he came out subsequently, or he and his panel came out subsequently with a report that recommended a narrowly focused GAAR, which is to say what I'm referring to, and what is in fact titled in the UK an anti-abuse rule and not an anti-avoidance rule. We'll see in a few minutes exactly what that looks like. There was a further consultation, there was a bit of tweaking, and the GAAR was included in the Finance Act with effect in 2013, with effect from 2017. Okay. It can be found in sections 206 to 213 of the Finance Act 2013, and it allows for adjustment of tax calculations to ignore abusive tax arrangements. And it came into force and only applies to arrangements. Sorry, I said it only applies from 2017. In practice, it does, but I'll explain that in a moment. It applies only to arrangements implemented on or after the 17th of July 2013. So they had originally thought about doing it a bit retroactively, as is often the case in UK. Often the case in UK tax legislation, as you may be aware. Not quite as much as India has occasionally attempted to do, but still fairly retroactive back to the beginning of the tax year or so on. They specifically did not do that. That's one of the things that came out in the consultation. The rules require that there has to be an arrangement, legally enforceable or otherwise, so it can be an understanding between the parties, that gives a tax advantage. And the tax advantage has to be one of the main purposes of entering into the relevant arrangement. That's part one of the test. And the second part of the test is that the tax arrangement must be abusive. Now, the statute doesn't go into great detail about what either advantage or abuse mean, but the guidance that HMRC provides goes into somewhat more. And in any case, both of these terms are quite well understood within UK case law. So in range, and they're both quite broad, right? So, and actually, so is. Well, tax advantage is discussed explicitly. So an arrangement is basically any structure, any transaction, and so on. And it does not have to, as the statute says, does not have to be legally enforceable. It can be an understanding between the parties. It has to give rise to a tax advantage, which is understood quite broadly to include in increasing a relief, lowering an actual tax liability directly, deferring tax liability, and so on and so on and so forth, and it has to be abusive. And abusive, in this case, rests really on the UK, case law in this area. But they put in an additional restriction because they wanted to narrow the scope. So it's sort of based on the concepts that exist in UK case law, but they put in a particular test, which is referred to typically as the so-called double reasonableness test. Or let's say they limited the understanding of abuse in the case law. An abusive tax arrangement is one which is, the entering into or the carrying out of which can't reasonably be regarded as a reasonable course of action. That's the so-called double reasonableness test. And in that connection, you're supposed to look at all the relevant tax provisions and look at all the relevant circumstances, right? And that's sort of what you would expect on from something that's ultimately derived from a case law principle of abuse, right? But it was deliberately kept quite narrow, right? So you have to find that it's not reasonable to consider it a reasonable course of action, and it's meant to be therefore a relatively objective test. It's not in the sense that it is not the subjective intent of the taxpayer or taxpayers that matters, but what a reasonable person would understand to be a reasonable course of action. Now, the procedure for this is that you have a designated HMRC officer within HMRC who has to notify the taxpayer, right? Now, what I didn't perhaps make as explicit as I could have in the bullet point is that this is centralized, right? So this has to come out of the compliance directorate of the and anti-avoidance directorate of HMRC, right? It is not with, let's say, the average assessment officer in HMRC. It issues a notice. It has 12 months to investigate. That's a little bit of an oversimplification because what they discovered was that taxpayers were deliberately stalling, or their advisors were deliberately stalling to try to run the clock on the 12 months. So there's now a so-called protective notice that allows HMRC to extend that period. So they issue this notice, or a protective notice. They have a period of time of at least 12 months to investigate. They investigate this with the taxpayer. If the taxpayer objects to this determination that there is that the GAAR can apply, then that is made by HMRC, then the matter has to be referred to an advisory panel. The advisory panel is appointed by HMRC, but none of the members are from HMRC. Okay, this is again one of the things that came out in the consultation, without going into a lot of history, concern about independence from the revenue authority. The advisory panel issues an opinion notice. These are published on the HMRC website. Either side may take this matter to court. Okay, so this is not binding in that sense, or is not sort of meant to be binding. It can be taken to court. And if it is taken to court, HMRC must satisfy a court that requirements are met, and that the requirements of it being a GAAR, of invoking the GAAR, which is to say that it's doubly unreasonable, if you will, and therefore the GAAR was properly invoked in the case. And second of all, that the adjustments that HMRC proposed are just and reasonable, right? So it has to establish to the court's satisfaction both of those. The court has to take into consideration the GAAR guidance. So the HMRC issues GAAR guidance against publicly available. It has to take into consideration the guidance that was in force, so to speak, when the arrangement was entered into, and it can also consider any other HMRC guidance. But as you would expect in a common law court, it can do what it wants. So it can accept in part, in whole. It can rule completely for the taxpayer, completely for the revenue, or somewhere in between. One other important point about the GAAR system in the UK, and this is again something that was raised in the sort of various discussions and the formal consultations, is the question of what the UK would call a clearance system, or what you call advance ruling in India, right? Can you go first to the Revenue Authority and say, I plan to do X, Y, and Z? Is the GAAR going to apply? Will you give me a ruling that says that the GAAR won't apply? Right? No such system exists for the GAAR in the UK. There are clearance systems for specific things, but not for the GAAR. HMRC specifically declined or Treasury specifically declined to make provision for this in the GAAR. That may well make sense given how it's been used. Because the scope of the application of the GAAR has been, perhaps unsurprisingly given the way it's been structured, quite limited. There have been 19 advisory panel opinions issued to date. You can see them on the website. I can drop the link. I think I have it open somewhere, so I can drop the link to you if you really want to look, but you can just Google it. They are the background, part of the background for the move towards aGAAR in the UK, which I didn't mention specifically, is that there were a lot of tax avoidance schemes that were heavily and widely promoted. And HMRC was not always happy, shall we say, with how the judiciary was ruling on them. So, to some extent, the historical background of the GAAR, so to speak, in the UK, as well as the way it was, specifically the way it was formulated, was intended to address a relatively narrow, arguably relatively narrow set of problems. And so far, at least, that seems to be the case. Now, when I mentioned 2017 before, what I wanted to say, or what I should have said, is that the first advisory opinion actually came out in 2017, considering the effective date and considering how long it would take a taxpayer to file a return, have that return reviewed by HMRC, 12 months probably or thereabouts, or possibly a bit more of investigation, and so on and so forth. It's not surprising that you didn't actually see an advisory opinion until about 4 years later. It's a bit less than 4. April 2017, if I remember correctly. So just under 4 years later. So it's been certainly from the revenue authority's point of view, a narrow but effective mechanism. Something that's sort of related, but that, again, I haven't mentioned, I don't want to go into very much, is that it's been used in connection with other things like so-called follower notices in the UK. So once you get one of these tax avoidance schemes, once you get an opinion saying that they're not acceptable, the HMRC has then gone to everyone to whom this thing has been sold as a tax planning mechanism and said, okay, you should pay up now because we've already got an opinion that says that this is not acceptable, right? So they've used it in connection with other mechanisms that exist within their arsenal, so to speak. So it certainly helped HMRC, but arguably only within, and arguably was only designed to help them within a fairly narrow set of situations. Now, by contrast, and this is, a system that I freely admit I'm less familiar with, but it's very interesting, and hopefully I understand it correctly. But it's very interesting as a system to juxtapose against the UK GAAR, because they both, the history sort of the recent history is similar. Well, the histories are both recent, and in some ways they're quite similar in timing, and yet they've come out very, very differently. So, as I understand it, they're first included in the Direct Tax Code Bill in 2009. It was introduced in the Finance Act. It got deferred, or the effective date got deferred. Reaction, again, unsurprisingly, was mixed. There was an expert commission led by Dr. Shome, who came out with a report. The revised version was then included in the Finance Act in 2013, and then you had an effective date that was again postponed, finally becomes effective in 2017. Now here, so one thing I didn't mention is that the scope of the GAAR in the UK is very broad in terms of the taxes to which it applies. So it applies to the income tax, which in the UK, as you may know, is limited to individuals and sole proprietorships. It applies to the corporation tax, which applies to corporations, as the title suggests. It applies to capital gains, which, because of the way the legislation was chopped up in the UK, applies to both individuals and corporations, very confusingly if you come from other jurisdictions or some other jurisdictions. It also applies to inheritance tax and various other taxes. It does not apply, the other probably most important tax it doesn't apply to is the VAT, because the VAT was covered under EU principles of anti-avoidance, and they're going to have to figure out how to deal with that now that the UK is no longer part of the EU. In India, of course, as you know, it rests within the income tax, right? So it's physically found within the income tax, and therefore it applies to taxes covered by the income tax. It's an anti-avoidance rule. It's very clearly an anti-avoidance rule, and it seems, at least as I understand it, to be much more aligned with the concept of substance over form, and as a backup, if you will, for the revenue against a much broader set of arrangements, transactions, etc., than was ever conceived of, at least from the Aronson Commission on, in the UK. And the requirements, as you probably know, or most of you know, is that you have to have an arrangement that satisfies basically two tests. One is that it has to have the main purpose. Its main purpose is obtaining a tax benefit. Originally, I understand that was one of main purposes, right? That became just the main purpose, and then satisfies one of 4 additional requirements. Results in rights or obligations that you wouldn't normally expect to see between arm's length parties, results directly or indirectly in abuse or misuse of the Income Tax Act. That one looks like, a bit more like the UK GAAR. Lacks commercial substance or is deficient in commercial substance. That sounds to me very much like a judicial, what I would think of as a common law judicial anti-avoidance principle. Not that that's bad, right? But again, the scope of this thing is very different. Or was entered into or carried out in a manner not ordinarily employed for bona fide purposes. What you might call, what's sometimes referred to, at least in North America, is doesn't pass the smell test, right? It smells funny. It smells rotten. Okay. So very different scope, very different conception, somewhat different technical formulation as well, but very different, more importantly, very different scope. And the tax benefit is defined as basically similarly as a reduction, avoidance, deferral of tax, or any other amount payable under the Income Tax Act. And I understand there's some discussion about interest and penalties and cess and so on. What exactly gets covered as a tax or other amount. Maybe that's already been settled since the materials that I've seen on it. And similarly, if what this so-called impermissible, or what's labeled an impermissible avoidance arrangement, an IAA, results in such a tax benefit, then the revenue authority can disregard it in whole or in part. It can reallocate, it can recharacterize, it can reassign. It has very broad powers. So very different, the powers, the notion of what constitutes a benefit and the powers are similar, but the notion of what's within the scope of this thing is very, very different, much broader in India. You have some specific safeguards. The second one is similar to what was put in the United Kingdom, right? So it only applies from a certain date going forward, and there are some provisions, as I understand, for grandfathering previous transactions and investments. The first bullet point is interesting from the UK point of view because there is no such safeguard or no such limitation, if you prefer, in the UK. So if all the parties don't, the tax benefit to all the parties does not exceed 3 crore rupees, this cannot apply, right? Now, in principle, at least, there is no such limitation in the UK, although I suspect that there is clearly no such limitation, and it's also clear from the opinions that have come out, the 19 opinions that have come out, that at least some of those situations, there was not the UK, the British pound equivalent of 3 crore rupees, right? Or 3 million pounds, or whatever you would want to. 3 crore rupees is less than 3 million pounds, but whatever threshold you would want, the threshold itself was fairly, the money involved in the particular case was not that high necessarily, but HMRC, presumably was going after it so that they could then go after everyone to whom, party in the broader sense, everyone who had been sold this tax instrument. Okay, so slightly, so the reality is probably similar, but it isn't built in as a specific safeguard in the UK one. And then you have this very specific, I don't know how relevant it, how many cases it involves, but a very specific disapplication to certain investments of foreign institutional investors. The procedure here also seems to me to be very different without having actually seen a case, in person as a practitioner, because an arrangement can be declared an IAA, apparently, if I understand correctly, by any assessing officer. Now they have to refer it to the commissioner, and then the commissioner is the one who issues the notice. But nonetheless, that suggests a much more diverse possible, origin of this kind of procedure, or this sort of invoking this procedure. The commissioner issues a notice. If he or she agrees, the taxpayer then gets to file his, her, or its objections, gets a hearing. If the commissioner doesn't agree with the taxpayer, then it goes to the approving panel. Effectively, this means that the burden shifts to the taxpayer. Well, I guess unless the commissioner it's very easy to convince the commissioner otherwise, but the commissioner is within the revenue, right? So presumably the commissioner is likely to agree, because the commissioner has already issued the notice, right? So effectively the burden has now shifted to the taxpayer, which is an interesting thing to note. If it goes to the approving panel, the assessing officer and the taxpayer have an opportunity to be heard. They issue a direction. The direction itself is binding. There's no appeal from that, but the taxpayer can then go to court. Right? But again, now you have a binding order, unlike in the UK. Right? So the burden here is, the burden of proof is somewhat different. And the other big difference is that the taxpayer can apply to the AAR, to the Authority for Advanced Ruling, for a ruling on the applicability of the GAAR in advance. Sorry, AAR, so it is in advance. But the point is, they can come to the AAR with the proposed transaction or structure, and that ruling then is binding on the commissioner and the taxpayer. So if the commissioner says, if the AAR says the GAAR doesn't apply, that's binding on the revenue. So you have that degree of, or that possibility of acquiring certainty for the GAAR. So it's a different balance. It seems to cover much wider range of transactions and structures, things that presumably, or taxpayers may have gone into assuming that there was not an issue. Okay, maybe it's a bit aggressive, but not that problematic. On the other hand, you can go into the Revenue Authority in advance and say, I'm planning to do X, Y, and Z, and I'd like a ruling that's okay. And of course, that puts you in the dynamic that you always have in these kinds of situations, not least that you're showing your hand to the Revenue Authority. And if they say that, no, it's not okay, well, you're stuck. You're really stuck, because they now know everything about what you were planning to do. Given what I know, again, as a non-expert about the Indian tax system and the Indian Revenue Authority and Indian tax litigation, it seems to me that this is going to lead, or perhaps has already started to lead, to much more aggressive implementation of the GAAR, and even with this option, or this possibility of getting an advanced ruling, more tax uncertainty, more litigation. There is already, I don't know what the latest statistic is, 8-9 lakh crore rupees arguably tied up in tax litigation in India, which is a phenomenal amount of money in any currency. And it doesn't seem to me that this will, at least in the short term, change that dynamic. If anything, it might aggravate it. So to sum up, I know we want to leave some time for questions, and so I've possibly left a little bit less than we'd originally said. But just to sum up, if your hopes are in aGAAR to reduce reliance on SARs, reduce the pressure on the judiciary, and illuminate the line between acceptable and unacceptable behavior, arguably neither of these two approaches is going to really accomplish that. Because the UK system, arguably, or at least my sense is, it really just gives HMRC one more tool to attack something they would have attacked anyhow. Right? So that it doesn't arguably add that much. So it's proportionate, but arguably not necessary. Whereas arguably in India, and I say this with a bit more trepidation because, as I say, I'm much less familiar with it and its application, but my sense is arguably it's necessary but not proportionate, because they're trying to attack questionable structures and transactions, but with a tool that is so powerful that it is likely to call more transactions into question than perhaps is justified. So I'll stop on that note, with that sort of open, if you will, initial sense of the two systems, or more importantly, how the two systems have played out or seem to be playing out, and whether they are necessarily the best approaches, frankly, in either jurisdiction. So I'll stop there, and then if there are comments, corrections, aspects of the system that I'm either unaware of or didn't make explicit, particularly the Indian system, questions, please, I welcome the former and the latter.
Thank you so much, Professor. We have a question from one of our students.
Mm-hmm.
Will it still be considered as avoidance if there is no tax liability established? Instance, like in case of investments in NFTs technology, there is lack of clarity as to how they will be taxed.
I'm not sure what the answer to that is, and perhaps one of the some of the people in the audience will know better than me. My sense is that the scope of the Indian GAAR, I assume we're talking about the Indian GAAR because you said the student said anti-avoidance. My sense is that the scope of the Indian GAAR is so broad that they could go in situations where the law is unclear. There's no reasonableness test in quite the same way, or double reasonableness test of the kind that you find in the UK law, in the UK GAAR, but also other aspects. I mean, the CBDT has said explicitly, I think it came from the CBDT, that they will apply the GAAR or the SAR or the relevant SAR, right? So the concept here it seems to be that, because some systems, for example, I didn't go into, in the interest of time and so on, didn't go into other various approaches, but some systems, for example, say very explicitly, we will only apply the GAAR if we think it's problematic and it's not addressed by a SAR. and that, or not addressed by transfer pricing and so on. So that my sense is that yes, it could be.
So we have another question. With the applicability of principal purpose test via MLI, that is multilateral instruments, and then the more recent global tax deal, how does GAAR still apply?
Well, the GAAR. So one of the aspects of there is some overlap there. That's of course true, and there is some discussion also about, or there has been discussion in the past, I think in India and certainly elsewhere, about the application of aGAAR to the cross-border context if it seems to conflict with a tax treaty. But for starters, there is no contradiction because the GAAR can be invoked, and in the UK, and in India has been invoked against domestic structures. Now, to the extent that the MLI eliminates the need to use the GAAR, then presumably it won't be used in that context. But the MLI is not going to cover everything. And I don't think the MLI, my understanding is the MLI itself does not preclude the use of aGAAR in a cross-border context. Britain, so on that note, on a related note, Britain has said that normal international tax planning, so the HMRC has basically said explicitly that normal international cross-border tax planning will not be subject to the GAAR because it's not within the scope of what is considered an abuse. So they've already cut that out of the scope of aGAAR. They haven't said any cross-border situation is not abusive, but if it's your normal tax planning that takes advantage of, hybrid entities, hybrid instruments and so on, lower rates, CFC regime, so on, that in and of itself is not going to trigger the GAAR. Now, I have not seen, I may be mistaken, but I have not seen India make any such categorical or relatively categorical statement, which again suggests, and again, I don't think the MLI requires India or any other jurisdiction to do so. So I think the reality is that it may wind up not being used in certain situations where there are now other ways of dealing with it. Just as I would expect, even though India has left the door open, I would still expect that they would use a SAR first, if they could. I hope that answers the question.
Thank you, Professor. And we have a last question. That if GAAR not properly implemented, will it affect the business sentiments and deter foreign investors? Are there any chances?
Well, I think it can. That goes back to the point we raised, which is this question of chilling the chilling effect, right? Because you want to chill you want to discourage the bad stuff, what you consider to be inappropriate structures and inappropriate transactions, but you don't want to discourage things in general. And it seems to me there are questions around how much is potentially within the scope of the GAAR in India in particular, and in some other jurisdictions. Again, this is not a problem that's limited to India by any means, or an issue that's limited to India. How much is within the scope? How much will you be able to argue as a taxpayer that listen, the law is just not clear, right? Because it does shift the burden, it shifts the power to the revenue authority and shifts the burden to the taxpayer to justify a proposed transaction, a proposed structure, a proposed way of merging or demerging or whatever it is. And it would be interesting to see. I don't know if there are any statistics in India for how many requests for advanced rulings have been made that are related to the GAAR. Because one of the things that I would expect to see with a GAAR that is so broad, when, as the students suggest, you have this potential for, I like the way you put it, business sentiment, right? I.e., they're afraid to do anything because they don't know what the tax treatment is going to be. You would expect that one of the ways to deal with this is to try to bulletproof, right, to protect your transaction or structure by going for an advanced ruling. So, and it's arguably a very good thing that option exists in India, given the broad scope of the GAAR, right? I'm less worried, so to speak, from a policy point of view, that there is no such regime in the UK because of the way the GAAR has been crafted and the way that it has, at least to date, been used. Right? If you had a much broader GAAR, I would say, wait a second, if you don't want that kind of chilling effect, if you don't want tons of litigation and lots of disputes, and litigation doesn't have to just be in the courts, it can be taxpayers fighting first with the, in front of the commissioner. It can be within the revenue first, or it will typically be within revenue first, right? So it's dispute and litigation. You would want to see that kind of thing. So I would expect that that's the case in India. Nervous taxpayers, a lot of extra business for big law firms or lawyers and litigators in India, which is good if you're planning to go into tax as your specialty, I say that half in jest, I'm trying not to be cynical, but as a practical matter, that's good for practitioners, and then you try to ascertain, you try to create that certainty some other way. And maybe you start to avoid certain types of transactions or structures that you feel are subject to this kind of challenge. And how the ruling system works matters, because in some jurisdictions rulings are published in redacted form, in some they aren't, and so on and so forth. So it will create an interesting dynamic between, or change the dynamic between, I suspect, between taxpayers and the CBDT and the revenue authority in general.
Thank you, Professor, for the thought-provoking session. With this, I'm sure that it will. Yes.
No, I was just going to say thank you very much, and to Professor Srivastava, who I see is online, and everyone at Nirma University for giving me this opportunity. I hope that the students and all the listeners have found it interesting and useful.
Yes, and I would like to thank our Dean and Director of ILNU, Dr. Professor Madhuri Parikh, for organizing such a wonderful International Teaching Month, and also Professor Shreya Srivastav for her dedication and support during the session. Thank you, everyone. Thank you, Professor, once again.
Thank you. Absolutely.
Thanks. Schneider.
Thank you. Thanks to both of you and to Director Parikh and to everyone else at the Institute of Law.
Thank you. Have a good day.
Have a good day.
And to you, have a good afternoon.
Thank you so much.